Caveat. The term caveat has not been defined in the code. The word caveat has been derived from Latin, which means beware. According to the dictionary meaning, a caveat is an entry made in the books of officers of a registry or a court to prevent a certain step being taken without previous notice to the person entering the caveat. In other words, a caveat is a caution or a warning given by a party to the court not to take any action or grant any relief to the applicant without notice or intimation being given to the party lodging the caveat and interested in appearing and objecting to such relief. It is very common in testamentary proceedings. It is a precautionary measure taken against the grant of probate or letters of administration, as the case may be, by the person lodging the caveat. The person filing or lodging the caveat is called caveator. Section 148A of the Code of Civil Procedure provides for a lodging of a caveat. Section 148A. Section 148A, as inserted by the Amendment Act 1976, is a salutary provision. It allows a person to lodge a caveat in a suit or a proceeding instituted or about to be instituted against him. It reads as under: where an application is expected to be made or has been made in a suit or a proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on hearing of such application may lodge a caveat in respect thereof. Where a caveat has been lodged under subsection 1, the person by whom the caveat has been lodged, hereinafter referred to as the caveator, shall serve a notice of the caveat by registered post, acknowledgement due on the person by whom the application has been or is expected to be made under subsection 1, where after a caveat has been lodged under subsection 1, any application is filed in any suit or proceeding, the court shall serve a notice of the application on the caveator. Where a notice of any caveat has been served on the applicant, he shall forthwith furnish the caveator at the caveator's expense with a copy of the application made by him and also with copies of any paper or document which has been or may be filed by him in support of the application. Where a caveat has been lodged under subsection 1, such caveat shall not remain in force after expiry of 90 days from the date on which it was lodged, unless application referred to in subsection 1 has been made before the expiry of the said period. Object. The underlying object of a caveat is twofold. Firstly, to safeguard the interest of a person against an order that may be passed on an application filed by a party in a suit or a proceeding instituted or about to be instituted. Such a person lodging a caveat may not be a necessary party to such an application, but he may be affected by an order that may be passed on such application. This section affords an opportunity to such party being heard before an ex parte order is made. Secondly, it seeks to avoid multiplicity of proceedings. In the absence of such provision, a person who is not a party to such an application and is adversely affected by the order has to take appropriate legal proceedings to get rid of such order. Such a provision is found in the Supreme Court Rule 4. The Law Commission therefore recommended insertion of such a provision in the Code of Civil Procedure also. Accordingly, 148A has been inserted by the Amendment Act of 1976. Nature and scope. Section 148A enacts that a caveat can be lodged in a suit or a proceeding. Considering the connotation in a narrow manner, some high courts have taken the view that no caveat can be filed in a first or a second appeal or in execution proceedings. But, as observed in Ramchandra Agrawal v. State of UP, the expression civil proceeding in section 141 of the Code includes all proceedings which are not original proceedings. Thus, the provision relating to caveat would be applicable to suits, appeals, as well as other proceedings under Code or under other enactments. Again, it is no doubt true that no order should be passed against a caveator unless he is heard. But if the caveator is not present at the time of hearing of the application and the court finds that there is a prima facie case in favor of the applicant, ad interim relief can be granted by the court in his favor. Interim orders passed without giving notice to the caveator is not without jurisdiction and is operative till it is set aside in the appropriate proceedings. Who may lodge a caveat? Subsection 1, 148A prescribes qualifications for the person who intends to lodge a caveat. He must be a person claiming a right to appear before the court on hearing of the application, which the applicant might move for grant of interim relief. The language of subsection 1 of section 148A is wide enough to include not only a necessary party, but even a proper party. Hence, a caveat may be filed by any person who is going to be affected by an interim order likely to be passed on an application which is expected to be made in a suit or proceeding instituted on this behalf. ఏమైంది మళ్ళా? Thus, a person who is a stranger to the proceeding cannot lodge a caveat. That is, necessary party can file, a proper party can file, but a stranger to the proceeding cannot lodge a caveat. Likewise, a person supporting the application for interim relief made by the applicant also cannot file a caveat. Generally, a caveat can be filed after judgment is pronounced. In exceptional cases, however, a caveat may be filed even before the pronouncement of the judgment. When a caveat may be lodged. Normally, a caveat may be lodged after judgment is pronounced or order is passed. In exceptional cases, however, a caveat may be filed even before the pronouncement of judgment or a passing of an order. When caveat does not lie, the provisions of section 148A of the Code can be attracted only in cases where the caveator is entitled to be heard before any order is made on the application already filed or proposed to be filed. Section cannot be construed to mean and provide that even in cases where the Code does not contemplate notice, it can be claimed by lodging a caveat. Such a construction would be inconsistent with the object of underlying section 148A. Form. Unlike the Indian Succession Act 16, no form of caveat has been prescribed under the Code. A caveat may therefore be filed in a form of petition, wherein the caveator has to specify the nature of the application which is expected to be made or has been made, and also his right to appear before the court at the hearing of such application. The stamp reporter registry of the court will keep a register wherein entries will be made of filing of caveats. Notice. When a caveat is lodged, the court will serve a notice of application on the caveator. The section obliges the applicant who has been served with a caveat to furnish the caveator at the caveator's expense a copy of the application along with the copies of papers and documents submitted by him in support of his application. Rights and duties. Subsection 2, 3 and 4 of 148A prescribe the rights and duties of the caveator who lodge a caveat of the applicant who intends to obtain an interim order under the court of caveator. Under subsection 2, section 148A, once a party is admitted to the status of a caveator, he is clothed with certain rights and duties. It is his duty to serve a notice of the caveat lodged by him by registered post on the person or persons by whom an application against the caveator for interim order has been or is expected to be made. The provision is directory and not mandatory. Where no notice could be served on account of uncertainty of the person likely to institute a suit, appeal or other proceeding, the court may at its discretion dispense with the service of notice of a caveat and permit a party to lodge a caveat without naming the party respondent of applicant. Subsection 4, 148A provides that it is the duty of the applicant to furnish the caveator forthwith at the caveator's expense a copy of the application made by him along with copies of papers and documents on which he relies. This provision thus makes it obligatory for the applicant to serve his application along with all copies and documents filed or intended to be filed in support of his application of the court. Once a caveat has been lodged under subsection 3, it is the duty of the court to issue a notice of that application on the caveator. This duty has been cast on the court obviously for the purpose of enabling the caveator to appear and oppose the granting of any interim relief in favor of the applicant. Although the expression notice of application has not been defined in the code, it would include the date of hearing. It must therefore be taken that it is the duty of the court to give sufficiently reasonable and definite time to the caveator to appear and to oppose the application filed by the applicant. This duty of the court is in addition to the duty of the applicant under subsection 4, and non-compliance with it defeats the very object of introducing section 148A, and the breach thereof vitiates the order. Therefore, merely because the caveator refuses to accept the copy of the application from the applicant, the court is not absolved from serving notice of the application to the caveator. Failure to hear caveator effect. The intention of the legislature in enacting the provision of caveat is to enable the caveator to be heard before any order are passed and no orders are passed by the court ex parte. It is therefore clear that once a caveat is filed, it is a condition precedent for passing an interim order to serve a notice of the application on the caveator who is going to be affected by the interim order. Unless that condition precedent is satisfied, it is not permissible for the court to pass an interim order affecting the caveator, as otherwise it will defeat the very object of section 148A. It also cannot be contended that the caveator is required to be heard not at the time of passing an ex parte order at the initial stage, but at the time of passing the final order. This reasoning could make the provisions of section 148A nugatory and meaningless, because even in the absence of section 148A, before passing a final order, other side is always required to be heard. This is the requirement of natural justice. Therefore, once a caveat is filed, it is the duty of the court to hear the caveator before passing any interim order against him. But an interim order passed without hearing the caveator is not without jurisdiction and operates unless it is set aside. Time limit. A caveat lodged under subsection 1 will remain in force for 90 days from the date of its filing. After prescribed period 90 days is over, caveat may be renewed for another 90 days.